Third case on this morning's docket, that is case number 114959, State of Kansas v. Terrence Sims.
May it please the court, I'm Ryan Eniger, Assistant Appellate Defender, here this morning on behalf of Terrence Sims. With the court's permission, I would reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you, Your Honor. Just a quick factual recitation of how we got here today. Mr. Sims was charged at district court level with 3 subsequent failures to pay the offender registration fee of $20. The first offense was a misdemeanor. The 2 subsequent offenses were felony severity level 9 offenses. Mr. Sims at the district court level filed a motion to dismiss these charges, attempting to put forth evidence of his indigency, which there is a statutory exception that the legislature has carved out, trying to accommodate this situation where a defendant is unable to make the associated payment for his registration. The issues raised in the brief revolve around an equal protection claim and a claim regarding a more or less a motion to suppress his statements under a Miranda claim. I think what really cuts to the matter of this issue before the court today is this question of, clearly the legislature considered that they were making a requirement to pay the registration fees and putting that on the offender. I don't think it was lost on the legislature that by doing so, you may have individuals considering the situation that are going to be unable to pay. In order to so therefore the legislature is creating a class of individuals all subject to the offender registration, all subject to the same requirements to pay. However, I think they tried to realize that we're going to have people that are going to be treated differently if they cannot pay. Obviously, the guiding principle here is that we don't want disparate treatment for similarly situated persons under the controlling law. So I think the statute tried to accommodate that by providing this exception where a criminal defendant or someone subject to the act can go and get a declaration of indigency. And that statutory, the problem I think that is inherent in that is clearly there's no real substance to this. There's no procedure that's identified in this exception that allows for a criminal defendant, generally somebody that's subject to the act. Frequently, these people are most likely just getting out of prison. They're going to be set up with, these are your registration dates. These are the things you need to do to comply with the act.
So is your complaint that while there is an allowance to consider indigency, there's no mechanism to achieve it or to acquire it?
Exactly. I think that's the largest problem here is in the way this sort of transpires, as it has in this case. If under that statutory exception, it requires prior to your reporting period or any time 3 years preceding that reporting period, if the offender can get a declaration of indigency, you're not subject to make the payment.
And what does that mean? What does getting a declaration of indigency mean?
I think that's exactly the issue that
What's your support for the idea that this is what I'm struggling with. Usually an equal protection, at least my basic understanding, is that it arises, an equal protection violation arises out of the law's differential treatment. Precisely. And here we haven't, I think what you're arguing is the absence of something. The fact that the legislature failed to also provide a procedure for obtaining that indigency qualification is the equal protection violation. And I'm just having a hard time getting my mind around the absence of
correct.
law
I understand.
being the violation.
I think that the idea of equal protection goes as far in this argument. How it's presented in the brief is we have 2 different classes of persons that are the statute's created 2 different or a class of persons, I'm sorry,
Subject to
one
the
of which is
requirement.
being treated, you can pay the fee, okay, that's fine. The other part of the same class cannot pay the fee. Those persons are subject to criminal prosecution. So that is where the disparate treatment would come in under the Equal Protection Clause.
But you're saying he's actually,
it's more of a due process problem.
okay.
I think what I'm saying is I think the legislature, it's apparent from the statute that they were attempting to sort of prevent a equal protection problem. But the issue is that fails.
And didn't they successfully do that by giving us an escape hatch?
I would say yes, probably so.
So, okay,
So
on
So
equal
we have
protection-
to
I
move
think-
to due process? Is
I
that-
think this is a due process problem. That's
And how
really
do-
what we have.
And how do we get there the way this case was briefed and
I
argued and
think
presented?
we can get there through this idea of, I would argue that substantive due process would have to include a procedural due process, and I know substantive due process was thoroughly briefed and addressed in the brief, and I know there was a 609 letter adding in another case to
Owens-
sort of the Owens case.
The Owens case is final. I mean, mandate
Correct.
is issued.
Right.
What do we do with that? I mean, we now have a court case that says this is an unconstitutional statute. Is your client entitled to the benefit of that case even though he hasn't made that argument? I mean, what is the impact of and how do we treat Owens? Do we just ignore it?
I think that Owens has to be considered in the context of this case as well, because this, I know the letter or the case was sent as additional authority, and an argument was made that trying to incorporate that sort of what really boils down to procedural due process under the umbrella of substantive due process. And I understand it's kind of a two-track thing, and I see where that's problematic, but. In this case, I think it's really the same. It's the same problem, and the case is going to come back. It's going to be the same problem. So I think it would be incumbent upon the court to maybe address that, even though it's not the explicit way that it was argued in the brief.
That's just kind of a judicial economy argument.
I think so. Yes. I mean this is going to be repeated, and it's going to come up again because clearly there's no mechanism here in this statute for somebody to. First of all, we don't know that there's any notice given. You're going to be registering. You're required to register. You're going to be required to pay this fee. But if you see under the statute, you can get a declaration of indigency.
So if we get to where you want to go, we get kind of look at equal protection, determine that the created kind of cure for that creates a due process type of concern or procedural problem. What do we do? What do you want us to do?
Good question. I think we want this conviction reversed, or
Is there a cure for this?
I think the cure is that I think the most efficient way to cure this problem is to say that the statute violates due process. Now, I know it's always brought as not as a facial challenge of due process, but as a apply to me. The problem is when we keep getting everybody coming forward saying apply to me, it's applied to me. Well, if it's as applied all the time, then the problem really boils down to the statute itself. And the legislature needs to be given an opportunity to address that and fix that so we can have a mechanism whereby this doesn't keep repeating itself. And a criminal defendant and an indigent defendant can go, okay, well, here's the process I need. And what happens frequently here, too, is now you don't get an opportunity. The first offense is a misdemeanor. Frequently, that's not being charged. So then you don't get a chance then to go in with just a misdemeanor and establish indigency to say any further, for the next 3 years or what have you.
If you're being prosecuted for a misdemeanor, would that prosecution allow for
And that's part of the entire problem. Exactly.
would that procedure then allow the court even to say no? During the phase of that prosecution, the court could say you're indigent, and that would satisfy the
Right.
the
I would
statute.
hope.
How would that work?
I would hope that at least it gives an opportunity to be heard, an opportunity to get before the court and make your argument, and an opportunity to, in a meaningful forum, to say, okay, look, I'm indigent. The reason I'm here is that I haven't paid that. So then maybe, that's what's so problematic.
I don't know if the court
about
would be
this,
empowered in that case to
So
to
are
just make the declaration. But I'm sorry, Judge.
I didn't mean to interrupt if you weren't finished, but, so are you suggesting that our remedy would be to strike, I think before, it appears in the declaration of indigency has to be before the crime, basically here? So you would have us strike the word before and just say if there's a declaration of indigency?
I think what needs to be addressed, and I think what the court could do, or I would hope that the court could do, is to say that part of the statute where the legislature has failed to provide a meaningful due process mechanism in order for me to secure my right that's supposedly there, and the remedy that's unconstitutional. That it's unconstitutional in that aspect, and so that the statute itself is not completely found unconstitutional, but the component, or at least the aspect of a failure of the legislature to provide any meaningful mechanism whereby a person who is indigent can understand and then secure the rights under that statute.
And what would be the minimal due process fix that you think could be imposed and you'd be satisfied?
I would argue that at a minimum, I think it's a difficult thing to administer, but I think at a minimum, a criminal defendant or somebody that's subject to this needs to be given notice, perhaps when they're released from DOC, perhaps at sentencing, perhaps through DOC in some way, that option is there, first of all. So we have some reassurance that notice is provided. Secondly, I think during the course of when that person goes to register, they need to be told, again, here, you have this option if you cannot pay. Third, there needs to be something there to, if I'm indigent, how do I hire counsel to get a declaration of indigency? And some of this is sort of, standing here representing an indigent defendant because they couldn't pay the fee.
Everybody keeps referring to this hiring of counsel as an absolute.
And that's
It's
right.
not,
That's
is
it's
it?
not.
No,
It could be an
okay.
administrative
Right.
proceeding.
That was
there,
also confusing me.
almost right. Or just I file a petition with the court. The court writes, "Here's just as I apply for indigent status to be represented by counsel, something similar to that along those lines, where all I do is fill out a form. I sign an affidavit. Here's my financial circumstances. The court reviews that and says, yes, it makes sense to me. You're indigent. You don't have to pay the fee." That can be revisited, I guess, in a temporal, circumstances change. I know there's a 3-year time limit on now. That seems fairly reasonable, I suppose.
Counsel,
That form?
Yes.
Go ahead.
I'm sorry.
a couple quick questions about your substantive due process argument.
Mm-hmm.
Is that grounded exclusively in the United States Constitution, or are you asserting a claim under the Kansas Constitution as well?
Well, I think I hadn't really considered that question, to be honest.
Okay.
And-
What do we know from your briefing, or do you just talk about substantive due process?
I think it's grounded in substantive due process. Just the United States Constitution is what is in the brief right now.
Okay. Assume with me that a hypothetical person who is charged and convicted under the statute is not indigent.
Mm-hmm.
Does the state have the power to imprison a person for failing to pay a $20 fee? In your view?
Is if the person is not indigent, the statute purports to give that authority.
It does. That's
It
my
does.
question.
And
Does
I
the
think
state have that
ultimately,
authority?
I know there's a pretty strong principle under the federal constitution and state as well that we don't have debtors' prisons, and that we don't imprison people solely on the basis, or convict them solely on the basis of an inability to produce a monetary damage of some kind, a monetary fee or fine or something along those lines. So yeah, I would say that up front that it is problematic to begin with. But I don't know that larger idea has been addressed, so.
I'm sorry, was the premise of your question that they're able to, they just refuse, or not?
Or don't pay for whatever reason?
Just don't pay, period. Okay.
Right, just a willful refusal, more or less. Correct?
Or even negligent, couldn't it be?
Right,
I mean, just-
right, or negligent, and that was addressed, I think, in the hearing here, that it was put on the record that this wasn't a willful or negligent or just reckless act on his part. He testified that I was getting about $530 a month at that point in time, and I didn't have the money to pay it.
Was there any testimony about inability to hire an attorney or access an attorney, or what his motivation was for not pursuing?
He did. There was a stipulated facts, and if my memory serves me correctly, that one of those stipulated facts was he did not have funds to hire counsel in order to get his declaration of indigency, which would make sense, I suppose. So I think, unless the court has additional questions regarding this issue, then I would submit the other issue on the brief.
Any more questions? Thank you, counsel.
I guess I do have one more if I could real quick. Can you give us a reason why, I mean, usually if new issues are argued, we have 3 exceptions for why we would consider those on appeal. Do any of those exceptions apply here as to why we should consider your new arguments today?
I think it can be decided solely on basically the legal idea of due process and what it means to have procedural due process. And secondly, I think that it's going to be an issue that will be repeated through the courts. Thank you.
May it please the court, Christopher Schneider, Assistant Wyandotte County District Attorney, appearing on behalf of the appellee of the state of Kansas.
Counsel, I'll just pick up where I left off. How does the state have the authority to imprison somebody for failing to pay a $20 fee?
The state has the authority to do it because the legislature has enacted a statute that makes that a crime. Now,
Can they make that, so do they have carte blanche to make anything a crime that they want, or do they have to have some legitimate reason?
I would hope that they would have to have some legitimate reason.
Well, is there a legitimate reason?
There is, and this court has indicated that before in State versus Scott and State versus Myers, which, as I cited in my brief, in which this court found that the purpose of the registration fee is part of the state's public safety interest in ensuring that certain offenders are registered.
How does the payment of the fee advance a public safety interest?
It provides, because as this court has held, it provides for the orderly, timely, cost-effective registration of offenders.
Well, what if the offender walks in and does everything he or she is supposed to do,
Okay.
except pay the fee?
Okay.
And isn't that what happened here?
And that's what happened here.
Right.
Yes, because unlike certain other states, and Illinois comes to mind, I think Georgia comes to mind, where the registering authority just flat out said, "You don't pay, we don't register you." That's not the case here.
Well, isn't the purpose of the statute being fulfilled? And the purpose of the statute is that people register, so for public safety purposes or for whatever purpose that the CORA is satisfied.
Right.
Public knows of his whereabouts. The whole that whole purpose is effectuated.
Correct.
By the registration. So how does payment enter into effectuating the purpose of the act?
Because providing for that public safety function.
Public safety function's been met.
Yes, but,
He's there, he's
but
registered.
providing for that costs money. And so
Well-
the legislature has said there will be we're going to impose an administrative fee to make this system work.
And the administrative fee, as I understand the majority of this court, says that that's not punishment because it's legitimately related to the cost involved in administering the registration. So that's the state's entitled to that because it costs money to administer the registration program. And so if they don't pay that $20, the state doesn't have that money to administer. Instead, they'll pay $35,000 a year to incarcerate them.
That's what this court has held. That the system that the legislature has set up here does further a significant state interest.
Usually defendants or appellants who have a case pending on appeal are often entitled to the benefit of appellate decisions that occur while their appeal is pending.
Correct.
Why does Owens not dispose of this case?
Because I think the Court of Appeals limited Owens to the specific facts of that case.
It was an as-applied challenge, I believe,
Correct.
but don't those facts mirror these facts?
Not exactly. I think there's certainly there are similarities, Your Honor, certainly, but not totally.
And what would the distinction be that you would make?
Well, I think because the financial situation of each of those individuals was different. I mean, in general, yes, they were not wealthy individuals. They were poor. They struggled financially. There is no doubt about that. But as far as the specifics, for a finding, because as I recall, in that case, when in Owens, when he did ask the court after charges were brought, I think after the case was disposed of at the district court level, to make a finding of indigency, I think at that point the court, if I have my cases right, the court said, not at this point. Your situation has changed, but should you not be employed, you can come back and ask me to make that finding.
Prospectively, but didn't the judge make a finding that this defendant was indigent at the time of each of the three failures to pay that were charged in this case?
In Sims, in this case?
In Sims.
I think well, yes, because I think we agreed that he could not pay. He was only making like $530 or something a month in disability, and that's all he had for income. So yes,
I understood the judge to make a specific finding that he had presented sufficient evidence that he had a lack of intent, lack of willfulness, and a lack of negligence in failing to pay the fees, that it wasn't due to any of those things.
right. Because prospectively, again, towards the end of this case, the end of this case at the district court level, that request was made, and Judge Clapper did make that finding. Yes.
Even if there are factual questions, is Sims entitled to a remand for the application of Owens to his case?
For the application of what?
Of Owens to his case, for the district judge to determine if it does control on an as-applied basis?
I'm not sure that he is. Obviously, if this court determines he is, then yes, he is. But no, because I think the court weighed, and and took into account again that the legislature has provided what I think we refer to at the trial court level as a safety valve by allowing someone to ask a court to find them indigent. And if this person doesn't do that, the court can't make someone do it. The prosecution can't make someone do that. That's available. I mean, it doesn't necessarily require counsel to do that. We get pro se pleadings all the time in cases, from criminal defendants or people who are situated as criminal defendants. We think about movements in 1507 cases, and district courts entertain, well, as does this court on occasion, pro se filings on a regular basis. So that safety valve is there for him.
What is the procedure? for doing it?
To go to the court and you basically file a pro se pleading and say,
In your,
I'm indigent.
in what? Where do you file the pro se pleading? What kind of a case do you file to do that?
well, you have, the obligation to register arises out of the criminal conviction, criminal case. That certainly is available.
On a closed criminal case?
It's not unusual, Your Honor, even on a closed criminal case, for pleadings to be filed after that case is closed, on pro se pleadings and the like, it happens. Yes, it does happen. That's not going to bar to something being filed in that case to address an issue. Now, procedurally, I mean, would an attorney do that? If were I, could I as an attorney do that? I'm not sure that'd be the proper procedure, the proper practice of law. But for a pro se litigant, I think it becomes a different story. The courts, this court has said, and I think the district court's view, at least in Wyandotte County, have taken a somewhat relaxed view of allowing those to be filed and to entertain them. So it would be the state's position that when we weigh the factors that are involved here, that, and particularly based upon the precedent of this court, that there is a significant public safety interest that's met by the statute, that there is a procedure, and is it the procedure that I would have written if I were one of the 165 persons across the street drafting the legislation? I probably would have drafted it a little differently. I would hope I would at least. But it's there, and there's a presumption that the statute is constitutional. And the legislature has provided a way, albeit maybe not the way all of us with law degrees would provide for, but they have provided a mechanism for persons who are indigent to obtain relief from the $20 registration fee.
Just so I'm clear on your argument, you're saying that the public is better protected when a registrant pays the $10 administrative fee than when the registrant does not pay the $20 registration fee, all other things being equal.
I think that is the position of the legislature in enacting the law, is because it does provide a way to fund that public safety interest.
Does that conclude your
That
presentation?
would, if there are no further questions, that would conclude my presentation, Mr. Chief Justice.
I do have a question on
Yes,
your
ma'am.
double jeopardy argument. I mean, not double jeopardy, I'm sorry, your Miranda argument. It appears that one of the notice of failure to pay that was presented to Mr. Sims had an alteration on the form. I don't know if you have those in front of you. But somebody on the copy we have crossed out in the words, "I do hereby acknowledge," and the printed text is $20 is due and owing to the sheriff. That was crossed out and a different amount was put in, which would perhaps indicate that they were accumulating what had been due before.
I think that was the case because and they did so because the sheriff, quite frankly, and I think Deputy Williams, as I recall, Deputy Williams testified, and I believe it was at the preliminary hearing in this case, that they did not proceed with prosecution immediately because they were trying to work with the defendant to meet his obligations and trying to give him additional time beyond what the statute required. And I think they put that in there because that was the total amount he owed, because I think it was right. That's exactly what that was.
But doesn't that change your argument? Because it's not just acknowledging that on this case he has 15 days to pay the $20. It's acknowledging that I owe money and I have not paid in other situations.
Well,
So it's basically asking him to confess his guilt to the other incidents.
I think it's asking him to acknowledge that he did not make those payments, yes. Yes,
Which is a crime.
right. But again, I still don't think, but again, we're not talking about a custodial interrogation here. Because the person's not in custody, the defendant's not in custody, he's not coerced in any way, he was free to leave, he did leave.
You might have a voluntariness issue nevertheless if he's required to sign it.
I'm sorry?
You might still have a voluntariness issue, even if it's not a Miranda issue.
Well, if he's required to sign it, but there's nothing that says he has to sign it, and if he walks out without doing it, there's not really anything the sheriff can do about that, because that's not a crime. It's, it's a way, and it's done in a way to, quite frankly, and I think Deputy Williams testified, to try to work with folks, so they don't get to the point where they're asking for prosecution.
Doesn't that illustrate the potential irrationality of charging somebody with a felony for failing to pay $20? If everybody's working overtime to make sure that we don't get this into the county attorney's office charged as a felony?
I'm not sure if it's irrational, as if it's just...
I mean, it sounds to me like what you just said is that what happens as a matter of what, on the ground, what happens is nobody wants this to go to a felony prosecution, so everybody works really hard to try to make sure that they get the $20.
I think that's fair, Your Honor. I really do. I think that's a fair analysis. That just as a matter of justice and discretion, and that to try to do what's right. And at some point, after you don't, and the legislature says this is what the law is, there's an obligation to proceed. But it doesn't mean that we can't try to exercise justice and to be fair, go beyond fair in trying to administer.
Do we have any more questions?
More questions? I would ask that the decision of the district court and the decision of the Court of Appeals be affirmed.
Thank you, counsel.
May it please the court, Ryan Edgar, Assistant Appellate Defender. Unless the court has additional questions for me, I'm willing to raise rebuttal at this point.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for the arguments this morning. Court will take this matter under advisement. Before I call the next case on the docket, I'm going to consult my colleagues. Does anybody want to proceed or without a break, or take a break and come back? Yes. Let's take about a 5-minute break because we have another justice coming in. Court is now at recess for 5 minutes.